Friends, good morning. Today our topic is whether police aid can be given in civil cases without requisition from a court. So, very recently, the Supreme Court Justices Naveen Sinha and B.R. Gawai were disposing the civil appeal number 8175 by 2019, which emanated from an SLP of 2013. They have disposed the case stating that without the court's order, the police aid cannot be given. This is the crux of the problem and the gist of the judgment also. So please remember, this is regarding execution proceedings, in fact, Order 21. So a person files or institutes a civil suit under Section 226 CPC. He files a plaint. The procedure will go on. According to Section 33 CPC, the judgment will be given and also later the order decree will also come. Now the point of execution of the so-called decree. So JDR and DHR, you are very well aware. JDR means judgment debtor and DHR means the person who got the decree holder. Right. Here what happened is Mr. Amar Singh, he purchased a property during 1973 or so. Right, but that property belongs to the government. So the government, according to Section 24 of the Land Acquisition Act, they have issued land acquisition proceedings. Please remember, the state has got eminent domain. They can alienate any property for that matter. Anyway, since it's the government property, they wanted to alienate the same, but this man objected, stating that he purchased it from by registered sale deed and he sold it some other person. This is Om Prakash. So now the dispute is between them. Of course, government is also a party to the same. The matter has taken so many twists and turns. Right now, ultimately, the decree was issued in against to Amar Singh. That is, he is the JDR. Right. What happened is, according to Order 21, Rule 25, what happens is whenever you file the execution proceedings, the court will send its officers or process server or Amin to the place to deliver the possession of the property. According to Rule 25, the person who took delivery, the person who takes the decree, that means the person relating to the court, he goes to the place, then along with the DHR, then he personally hands over the so-called immovable property to the so-called DHR. If at all JDR raises objection, then under certain circumstances, when he is not able to deliver the property, according to Rule 25, what Rule 25 says is that he has to come back to the court and record the reasons for not delivering the possession of the property to the DHR. Then the court will record the reasons, then the court will record his statement and the court will take its action. That is Rule 25. Please remember, according to Rule 35, Rule 35 also says that if the person or if the court officer goes there and tries to deliver the property, immovable property, the JDR should give him free access. If not, the JDR can be removed and the access may be given to the DHR. This is Rule 35. And Rule 35C says that when JDR refuses to give access, the court through its officers, please remember, the court through its officers may break open the lock or may put the DHR in possession of the property. Here, through its officers is more important. But normally, according to legal parlance, officers means the court officers. Right? Now, coming to the point of police aid. So, even if that is not possible, still he is a very repulsive fellow. He will not take, he wants to take the law into his own hand and he raises objection. Then, in certain circumstances, the police aid may be necessary. So, where the correct order for getting police aid is mentioned in CPC. Of course, I also do not know, nobody knows. But normally we file petitions under 151 CPC because court has got the inherent powers. We file a petition under 151 CPC to give police aid. Of course, if the court gives police aid, then you can take the assistance of the police, then the delivery process will be continued. Here what happened is, the warrant for possession was issued by the court, but he refused, saying so many objections. Ultimately, the warrants were also being returned. Ultimately, the warrant with some due date, maybe on 11/10/2013, was given to the Tahsildar. Right? The executive magistrate, then he consulted his superiors, and ultimately through the district magistrate, that is through the district collector, he approached the deputy commissioner of police of the city, and ultimately they gave the police aid. With the assistance of police, the Tahsildar went there and handed over. The process of handing over or execution was done on 11/10/2013. Since the date was fixed, warrant date was fixed on 13/10, they have executed the same on 11/10. Now, the JDR once again approached the High Court. High Court said yes. High Court now has very clearly stated that JDR, when he is in possession, the court can dispossess him. But when he refuses, the matter should be recorded in the court, and the court has to take steps like ordering for police aid, all these things. Here, nowhere it was mentioned that the court was requested for police aid. That means Tahsildar did not request the court for police aid. He, being an executive magistrate, or he is having good terms with the police, he got the police aid through the DCP. So here, very clearly, the High Court stated that High Court reverted back the judgment and ultimately asked the JDR to occupy the same. Alright, fine. Now the matter came to the Supreme Court. Here, the Supreme Court found fault with the order of the trial court, and of course it has upheld the decision of the High Court, stating that police aid cannot be given without court order. This is the most important one. Please remember. So normally, whenever you want police aid, you have to request the court only. Unless the court gives a direction of police aid, you cannot directly approach the police and take action. But this happens normally by the powerful people who have got influence with the police circles. Normally, after taking the execution petition, along with the court officer, they come to the police station, they give a requisition that the defendant or the JDR is a powerful fellow, he will not allow them to go for the execution proceedings. So, if the SHO is satisfied that there is a law and order problem, normally under the guise of law and order problem, they will send some persons, that is nothing but police aid, and the work is finished. When work is finished, we can't do anything. But now the Supreme Court has clarified that without a court's order, you cannot get police aid. That's one point. Second point here, now the JDR is unnecessarily, he has unauthorizedly in possession of the property. Now what the Supreme Court said is, even though the process is not correct, now this DHR has got a right to file a fresh suit. If he files a fresh suit, then the matter will be heard and ultimately the orders will be given in favor of the DHR. Of course, the JDR will be dispossessed at any point of time. There is no other go for it. But since the process is not correct, the Supreme Court did not agree for the lower court judgment. While upholding the judgment of the High Court, once again they gave a chance to the so-called DHR to go to the court and request for police aid so that it can be granted. It is nothing but just a procedural wrangle. Please remember, without court's order, no police aid can be given. Normally, police they don't give unless you are influential or unless you satisfy them that there is a matter of urgency or law and order problem may come. So, with this I want to conclude. Please remember, in civil cases, police aid should not be given without court's order. Court order will be given under 151 CPC. Thank you very much.